Welcome. This is Know Your Rights New Jersey, and I'm your host, Rhinold Ponder. Today, we're going to discuss sexual harassment in the workplace. We're going to talk about what sexual harassment is, how you recognize it, and how you handle it. We're also going to discuss your rights and responsibilities of the employers when those situations should arise. So this should be a very interesting and informative discussion. And to help us along, we have two extremely knowledgeable and experienced guests we'd like to welcome. And first, I'd like to welcome Andree Laney, who is the CEO of Laney HR and Consulting.
Yes.
And very accomplished. You've also worked extensively on the employer side, as
Yes.
well as a senior trial attorney with the EEOC.
Yes.
I'd also like to welcome our other guest, Melanie Griffin, who again is an activist in this area and has worked extensively, including stints as the executive director of the New Jersey Commission on Sex Discrimination and Statutes, EEOC trial attorney, and also at Rutgers as the director of offices and harassment compliance and affirmative action.
Right.
That, a mouthful, because you've all
was a big job.
done a lot. But even with that introduction, what I'd like to do is I'd like to start the show by giving our guest an opportunity to tell us a little bit more about your background and about what led you to this particular field. And I'd like to start with you, Andree. Tell us a little bit more about what was your passion to work in this area?
Well, I think passion is a good word to describe it. Certainly, my passion arose in law school with the understanding that as a lawyer, I could become an advocate and a spokesperson for people who could not necessarily speak for themselves or who perhaps would not speak for themselves. And it aligned with my personality in as much as I've always been a great defender of others, if perhaps not of myself. But with respect to the workplace, watching my parents as immigrants who had to figure out how to maneuver the work world for working class folks in this country and how to work in one instance with unions or in another instance without unions, and figure out how to make their rights heard.
Right.
That resonated with me. Okay. And I saw law as a means of speaking on behalf of people like them. And once I became a lawyer, as you've said, I have also worked representing employers because it's become apparent to me in the near 25 years of my legal career that employment law, which is the focus of my passion, really speaks to the rights and responsibilities of people. And businesses, corporations, employers are people. And they have to be educated and see the value in compliance as well.
Okay. Melanie, what about you?
Well, I guess I came to it from kind of a different place because I started out doing work with developmentally disabled adults.
Okay.
And ended up going to law school just kind of as a way to complete my education. But once I was there, I got very interested in women's rights issues,
Right.
legal issues, which I had always been interested in kind of as a sideline, but certainly it meshed with my ideas about rights for people with disabilities. And throughout my career, my legal career and before that, I've been concerned with enforcing rights, with looking at people who have less power in the various systems, employment systems, educational systems, the legal system. And so I have gravitated towards that kind of work. I've also done a lot of work with domestic violence, which has a lot in common with the dynamics of sexual harassment and other kinds of civil rights harassment. So that's kind of the theme through my work has been the empowerment of people who don't have as much power granted to them.
So let's start with you right there. Tell us, what is sexual harassment, and is that a form of devaluing and taking power away from anyone?
Actually, it's a subset of sex discrimination. The way the law sets it out, maybe it doesn't feel the same quite as not getting hired for a job because of your gender, but sexual harassment is a form of sex discrimination under the federal and state laws and some local laws. So really what it is, do you want me to go into kind of the definition?
Please.
The classic definition is that there are two kinds of sexual harassment, quid pro quo and hostile environment. Quid pro quo means you have to do something, this for that in Latin. So you have to do something to keep your job, and you have to do something sexual, if it's sexual harassment. So that's the classic example of the boss saying, you know, come on this trip with me to someone who works for him. And while you're there, obviously, we have to have sex or you're not going to keep your job. It's almost never that explicit, but that's the trade that's made. Or promoting someone who the boss is in a sexual relationship with. So that can be sexual harassment of the person who's subjected to the sexual harassment, and also sexual harassment of all the people around who didn't get that promotion.
So is there also something called third-party sexual harassment? Is that what you're referring to?
That's what I described, yeah,
Okay.
where the person who's not even involved in the relationship is affected by the harassment. But the other more frequent, more prevalent kind of harassment is hostile environment. And that can also take place on the basis of other categories of protected classes, race, national origin, religion. But the sexual harassment, really, it's a very different standard from, say, sexual assault, in that although something like that may happen in the workplace, the key is that the person not only feels like the environment is hostile to him or her because of their gender, but a reasonable person of that gender would also feel that way. So it makes it impossible for the person to be comfortable at work. And that's the essence of hostile environment. And it's got to be either severe or so ongoing and pervasive that the person really can't be comfortable there. Often people quit because of sexual harassment, hostile environment harassment, and nobody ever hears about it. Right. But it's an environment, and that continues. As long as people who are in the position to stop it don't stop it, that will continue, and eventually it will come up.
Well, let's jump to people who are in a position to stop it. And let's talk for a second about what the responsibilities are of the employer, and not just when situations arise, but do the employers have responsibilities before in terms of prevention of the situations, those type of situations?
Absolutely. Employers have myriad responsibilities that have to do with how they control, monitor their environment, how they train their supervisors, and how they make their work force aware of any policies that they have, and indeed they should have policies that make clear that sexual harassment and other forms of discrimination based on protected categories, such as those that Melanie has identified, is unlawful. So when you have an individual who is subject to unlawful sexual harassment and who does not know that there is a complaint procedure because that procedure either is not in existence or hasn't been properly published, or perhaps the employer has created a mechanism that is so unwieldy or unattractive to that employee, she would have to perhaps complain to the person who harassed her, then that is not an appropriate mechanism to control the environment. And that's what the courts will look at. They will look at whether or not the employer has lived up to its responsibility, its duty to ensure that it's taken all reasonable steps to create a harassment-free environment by apprising both employees and supervisors of their rights and responsibilities to ensure a harassment-free environment. So you need a policy. You need a complaint mechanism, and these are the things that employers should do prior to the incidents of sexual harassment arising.
So let's break down for our viewers a little bit in a simple sense. What do you mean by a complaint mechanism? What is a complaint mechanism?
Okay. It can be as simple as a couple of paragraphs in an employee handbook or a poster that is easily accessible and visible to everyone that indicates that we do not tolerate sexual harassment. And what is sexual harassment? Some people may not know what that means. So as Melanie has defined it, it can be either quid pro quo harassment, or it can be the harassment of the sort that creates a pervasive environment of demeaning behavior to individuals of a sexual nature, and that environment should be one that an employer helps to define and make recognizable to its staff, so that they are armed with knowledge of what their colleagues or supervisors are prohibited from doing and what they themselves are prohibited from doing.
Now, are there employers required, as part of that complaint mechanism, to have assigned departments, individuals to complain to resolve or address certain situations?
Well, again, it will depend to some extent upon an employer's size, but it may have an HR individual. It may have certain individuals in positions of responsibility. If it's a small organization, it could be the CEO herself, but with a somewhat larger and more matrixed organization, you would likely have a human resources department or an equal employment opportunity department. In some instances, in unionized shops, you will have, in addition, shop stewards or union representatives to whom you can complain. But the most successful of these policies are the ones that provide many alternatives, because you will find that the unfortunate reality is that people will leave the workplace before complaining in some instances, because they find the prospect of complaining and being retaliated against so real and unattractive that they're not willing to take the chance. So they remain in a bad environment and suffer what can only be considered psychic harm, if certainly no more physical harm than that, and they eventually leave. Sometimes when they leave under those circumstances, the claims that they might bring against the employer leave with them, and that would be unfortunate for everyone involved, because employers should be concerned about retention of employees. Good talent is hard to come by and hard to train, and that's a waste of money walking out the door. And you know, more importantly, they should not want to think that they haven't taken steps to prevent the flourishing of an environment that's toxic for female or male employees, for that matter.
Yeah, I think it's one of the brilliant pieces of the law. One of the brilliant aspects of the law is that it makes the employer responsible.
Yeah.
It doesn't allow you to identify a bad apple and just toss him out. It says the employer is responsible. The employer has to pay damages. The employer is responsible for having something that works. And if they have something that works, if they have a complaint procedure that generally works, that's a complete defense to some actions of hostile environment, sexual harassment. So if someone comes to a lawyer, or someone comes to the EEOC, or someone comes to the New Jersey Division on Civil Rights and says, you know, I couldn't complain to my employer, so I'm just coming to you. The first thing that investigator is going to ask is, what's the policy of the employer? How has it worked for people? Do you know people that it hasn't worked for? And they will advise the person to go back and go through the process if they haven't. So employers can really get a lot of benefit out of not only having the policies, but making sure they work and making sure that it's very well known that this kind of behavior is not tolerated. And I think what Andree said was very important too, and I do want to say that the Rutgers policy that was developed in the mid-90s was an incredibly insightful policy, I think, because one of the things that it set up was a system of advocates who I trained as director of the office, but they were all they were from students, faculty, staff. Anyone could volunteer to do this and was trained by my office. And we tried to get a real cross-section of every kind of person that you could imagine: gay, straight, female, male, black, white, Asian, Hispanic, whatever, to try and make sure that there was somebody that a person with a complaint could go to, feel comfortable, feel like they're going to be understood. And the first thing we said to them in training was, no matter how bizarre the situation seems that you're presented with, believe that person, because you're the person who is their advocate through the system. And I think that that's a really strong message that was sent because that system was set up that way.
Now, although you both have been very careful to phrase it in terms of person, we often think of sexual harassment as only occurring against women. Is that true? Can others suffer sexual harassment? Oh, you laugh.
Statistically,
Well,
it's probably mostly women harassed by men. I mean, that's this is where my domestic violence stuff comes in, but it's all a matter of power and control. It's not about sex, generally. Like sexual assault is not even about sex most of the time. Sexual harassment is about maintaining or gaining power over someone else. And so it can happen either way. Normally it takes some kind of supervisory role. If it's not a supervisory role, if the power dynamic is shifted because the underling is the boss's son or something like that, I mean, that can happen. But normally it's somebody in power trying to maintain or create power over someone else. And because of the way society is set up, that's most often men over women, majority whites over minorities, that kind of dynamic that leads to harassment.
But certainly there have been cases with which I'm sure we are both familiar from our time at the EEOC that involved what might be seen as variance on that theme. Women who were harassed by other women, and maybe the harassment was sex harassment, and here we draw certain distinctions between sex harassment that I might endure because of my gender, and sexual harassment, harassment that is of an overt, sexually oriented nature. And in those instances, the women would come to the agency claiming that they were subject to sex harassment because they were attracted. Or there were men who would claim that they had suffered sexual harassment at the in the instances where other men had sexually harassed them because they felt that they were gay and or effeminate. And so, you know, it's a fascinating area where really, as Melanie has stated, it comes down to a feeling that someone is trying to wield power over another, and they're using your gender or they're using sex as a threat or a weapon in some way against the other party. And that's usually the nature of the allegation. And by no means is it only of claims of men sexually harassing women. While it's the majority, by no means.
But power is really significant in this, in the power relationship. And later, if we have time, I want to talk a little bit about the Vance ruling, which sort of shifts the idea of power. But right now, I'd like for you to talk to me about, let's phrase it in terms of a woman, but a woman who is now in a situation that she thinks is a sexually harassing situation. At the very early parts of it, what are the variety of things that she should be doing? What should she be doing? If she was coming to you to ask for help, what would you tell her?
I would say write everything down, keep a copy at your desk if you have to, but take your notes home with you. Make sure that if you feel comfortable, you confront the harasser. If you don't feel comfortable, tell your harasser's boss that you feel uncomfortable. Talk to other people in the workplace who who you think might also be victims of the harassment or might be bothered by whatever it is. Say it's just someone has put up posters of naked women or clearly sexually provocative posters of women around the workplace, and they're making you uncomfortable as a woman. Talk to the other women at the coffee, at the coffee machine, and say, how do you feel about that? Kind of get a sense of whether your reaction is normal. But I think that the first thing that you really need to start doing is documenting exactly what happened and when it did. If you think that you're in a situation that feels like it might get worse, or you feel like you're being targeted, I just encourage the person to keep notes and come back as often as possible to talk about it.
Should the person be keeping pictures? Are we in New Jersey allowed to tape certain situations, record?
You can record things whenever you want. It's a matter of whether they're going to be admissible in court later. And maybe you don't need them to be admissible in court, in which case, sure, go ahead and record, as long as you're part of the conversation in New Jersey.
One party.
Right, one
has to
party
know.
has to consent. Some states it's different, but here.
But I think also part of what you're saying, though, is contemporaneous writing, contemporaneous conversations, which
Absolutely.
essentially
Journal.
as
Absolutely.
it happens along the way. Now, as you're also dealing with the incidents, should you be making some type of record of how it's impacting you on the job, how it might be changing your position at the job, or how you feel about your work?
Well, certainly, if you're feeling as though because you're subject to harassment, let's say by a supervisor, that you're no longer working optimally because, let's say it's quid pro quo harassment, and he has told you that you will no longer get plum assignments because you refuse to sleep with him. In an instance such as that,
You don't have to record anything. You just go right to the HR department.
yeah, I mean, to the extent that it is quite clear thereafter that some assignment that you otherwise would have received, you did not receive, you have full proof that his threat, if you will, has resulted in a tangible employment action against you. And you did note the Vance ruling. In light of the Vance v. Ball State University ruling last year, tangible employment actions are something that certainly all employees and employers should know about. And we should be striving to ensure that those actions do not occur to the detriment of individuals who have been subject to sexual harassment, be it quid pro quo harassment or hostile environment harassment. And basically that's to say that something bad has happened that has shifted your position in the job and has resulted in your having perhaps a less favorable work assignment, you've made less money, you've been transferred to an unfavorable locale. You have to demonstrate that some action as an employee has been taken against you by either the employer, which again, employers, they're people. So you have to show that the employer's agents, those people who are assigned by the employer to supervise you and direct you, have taken steps to punish you, if you will, because of your refusal to subject to sexual harassment in some way.
Well,
or
And the
you're
other
complaining
thing,
about it.
The other thing is, even if you're wrong, even if you do not, even if you got that job assignment, that terrible job assignment, because they just liked somebody else better, and it turns out that you weren't being sexually harassed at all, if you complain about it, you have protected some of your rights against retaliation. Because if somebody comes back later and says, oh, we don't want to promote her because she was such a whiner, later that can be a claim all on its own that you were retaliated against for complaining, or for even pointing out, say I'm not the one being sexually harassed, but you know that there's something going on in your office. If I go to HR and say, I think there's this problem, whether it turns out to be a problem or not, I am protected now from retaliation for pointing out that the employer has bad policies or has a bad practice.
So I have now gone to the employer. I've read the policies.
Right.
The HR says they're going to do something. They have not. At what point do I now seek outside legal professional counsel, and what should I expect to bring to counsel?
Well, certainly, you bring a copy of the employer's policy to the extent that it's part of a handbook or other document that you've been provided that shows that they understand what sexual harassment is. They have communicated a policy to you that tells you that they prohibit sexual harassment, and they say that you are encouraged to complain to identify people or positions when you feel you've been victimized by it, that you will not be subject to harassment if you complain, and that they will promptly investigate. And all employers have a responsibility to promptly investigate and appropriately respond to complaints of sexual harassment. So if in your complaining you feel that they have taken no steps to promptly investigate and remedy the situation, or indeed the investigation has somehow resulted in your suffering retaliation, perhaps from the harasser or from others in the organization, then yes, at that point, you have a claim. No employer should let it get to that point, but at that point, you want to seek outside assistance. Assuming you've gone back to the employer and you've said any results, and nothing has come of that, and you feel that you've been subject perhaps to further harassment as a result. Sometimes employers won't tell you what they're going to do or how they've addressed a situation with a harasser, because indeed you may feel that he or she is a cad, but that individual has rights, some privacy rights or expectations themselves. So in those instances, employers may discreetly transfer the individual and then come back to you and tell you that the situation has been resolved. If you feel the situation has been resolved, you may not want to pursue it further, but if you are still fearful or indeed have been subject to some sort of retaliation, you may wish to inquire about your legal rights.
Even if you've already suffered some detriment to your career, you feel that you've just not gotten that promotion, and they haven't come back and said, all right, we're going to do it. But the way you complain is to go to either the Division on Civil Rights or the EEOC. Either one will work. You can go and they will file cross complaints. You only have 300 days to do that after the last act of harassment. So, you need to do that. But even if you go to a private attorney, often they will say, go file with the EEOC first, because that's free, and they will do a prompt investigation. Your employer will be put on notice at that point.
And they are required to respond to the complaint from the EEOC?
Absolutely.
Certainly.
Yeah, they know that not responding is not a good sign.
Yeah.
And so what, if I do have a case, what should I expect from the EEOC at any point?
Well, when you call, you'll get somebody who does intake. Or you can call and ask to talk to the attorney of the day, and they will tell you about the process. Or the intake people will do that when you call the main number. And they will tell you, they'll give you an appointment to come in and fill out a formal complaint. Sometimes they'll send you the forms online so that you can do some of it at home. They'll tell you what to bring, and you can go into the office and meet with a counselor, an intake counselor, who will then take your complaint, and that starts an investigation.
Well, this has gone by so fast. But I like to end with, what is it that you believe is the most important thing for our viewers to take away regarding how to handle sexual harassment?
I think if your viewers are employers, then your viewers have to know to have a policy, to make sure that it works, to make sure that if you get a complaint, you take it seriously. And that if you get something from the EEOC or the Division on Civil Rights, that you answer it promptly. But mostly to make sure that your workplace is accepting and that the atmosphere is such that all of your employees know that the kind of behavior that we would call sexual harassment will not be tolerated.
Certainly. And I would say that, in addition, employers should know that you cannot escape liability or avoid liability by making someone who has clear responsibilities for the work assignments or the access to promotions, something other than a supervisor. With the Vance v. Ball State Supreme Court ruling, certainly employers do understand now that they're only immediately and vicariously liable for the acts of their supervisors. But certainly, individuals may be called something else and may still be found to have supervisory responsibilities for their employees. And if someone is being harassed by someone who has supervisory responsibilities, that person is going to have a claim against the employer, and the employer will not be able to hide behind a policy or a complaint mechanism that didn't work.
Ladies, this has been very informative and wonderful. Thank you very much for joining us. And I'd like to thank you for joining us. And until next time, be well and do good. Thank you.